separately for governor separately, and come to 339 in some Singh. Well, in fact, Your Lordship, I don't have the time today. The final hearing note will give that. And when matter came to Constituent Assembly, a very interesting exchange in 3 pages. I just digress for 1 minute. Lordship will be interested. Dr. Ambedkar was pressed by many members that you must have an elected governor. And you must have some powers to governor beyond 163. He gave a very nice reply. He says there cannot be 2 swords in one scabbard. On the contrary, we are going to nominate a governor, and I expect that very few people will be ready to take up the post of governor because the power must lie with the elected CM. There can't be 2 swords in one scabbard. Ek myan mein do talwar nahi, as they say. Now, see that sentiment from Shamsher Singh. Under the cabinet system of government is embodied in our constitution. The governor is constitutional formal head. All his powers and functions conferred, etc., are in spheres. So, while they give the whole of Shamsher Singh rightly. And Shamsher Singh is dispositive because it is 7 judges. It's the fountainhead. Then they cite 20-year-old MP Special Police Establishment. 20 years old at page 340. Then they cite a series of cases starting at 341 bottom. Gujarat Mehta is one case, and page 342, para 68, some portions are bold-faced, 342 and 343. These bold-faced portions are important. This is all the cabinet, considering it. But I'm going to come to the facts, which are very interesting in the cabinet. Then, Yedurappa, the one I just read to Your Lordship, is the 344 bottom. Where is any of this addressed by the governor? Your Lordship, he can reject it. He can accept it with reasons. Where is it? It's not addressed. So 344 bottom is important. Yedurappa cited. Then now come to 346. 346, where the factual matrix starts. 3 pages here, I must shorten it by just giving Your Lordship one part of the factual matrix. I am totally against Your Lordship looking into it. Nobody is asking you to. But Your Lordship should know what has happened. If Your Lordship will note 5 dates for this.
Yes.
In I'm giving Your Lordship not actual list of dates, a broad dates. September 1992, there is a land acquisition notification, which is denotified in June 98. So 92, then 98. In 2004, there is a sale deed in favor of my brother-in-law. It's a sale deed. It's not some agreement to sell.
After denotification.
So 6 years later denotification, 6 further years later purchase. So it's 12 years from the beginning. Then there is conversion of land in 2005 for various activities, residential, etc. in 2005. In 2010, my brother-in-law gifts it to his sister, that is my wife. In 2010, there is no issue on gift being bad, etc. The actual brother and sister. I mean, that's not the issue here. Each is 3-4 years apart. Nothing has got this present chief minister involved in any manner. He was not in power even in many of these dates. At all. 2014, an application for compensation is made. So now Your Lordship has reached 4-year gap again. Why, Because somewhere in 2012 or 13 it is found, this is missing in the sequence I'm giving, that though denotified, the government cut out plots and acted on the plots. It happens sometimes. The Lordship knows sometimes in non-acquired land, the government acts on it, builds a wall, takes it over, gives it to these 100 people, creates equities. So, in such matters, even Your Lordship does it many times, that you can't reverse the acquisition.
Compensation.
You give compensation, cash or kind. It's a very normal thing. 100 of the judgment do it. So that application is invited by the government and made in 2014 by my wife, who is the sister of the donor. She is the donee. In 2020, everything is 5 years later. There's no hurry, there's no urgency, nothing. Not like the governor who gets a complaint today and issues a show cause same day. In 2020, a resolution is passed saying, obviously your land is acquired, you have to have compensation. But we will give you, as we are giving hundreds of other people, half of the developed land. So 1/4 effectively is the compensation you will get. So, Maharaj, this is the land used wrongly. First take half of it, then half of that half, developed portion will be given to you, which is what is given to me in 2020. And a sale deed is executed in 2022 in lieu of as compensation was given to me. Now, just Your Lordship has got the whole facts. In 2024, along come these complainants, fellows, and they select one public servant out of 32 years from 92 till today, who did denotification, who allotted, who invited compensation, who gave compensation, not to me, to hundreds of others. But those hundred of other beneficiaries apart, there must be tens of officers of government who are public servants. This private complaint is born when I am Chief Minister on events starting 30 years ago, where only one public servant, the Chief Minister. It reeks of legal balance. On the same day the governor will issue notice, Balas. Who do I come to, Balas? I can only go to the High Court because there's a friendly governor and the constitution has been upturned, Balas, completely. Now, on these facts, kindly continue. Come to Balas, page 347. I am saying this is all discussed by the cabinet. You don't even, Balas, treat the cabinet worth looking at. So, my lord, is at 351. Sorry, 346 is a factual matrix. Skip all that, Balas, and come to 351. My lord has got it?
Yes, yes, I am there.
I am doing speed reading, one para only. I'm not
No
reading.
problem.
It is evident from the record that the ownership was changed from so-and-so to so-and-so to Malika Arjun Swami. He's my brother-in-law. All this is happening at a snail's pace over years. Then 355. I'm not hiding anything. Anything I can, when I want to read, I can read. But I'm just narrating. Just 355. 355. The government of Karnataka makes a single member inquiry commission under the Inquiry Commission Act on 14/7/2024.
This is PN Desai.
That's right.
Yes.
To look into it, very well, it's something or the other. They'll report. It's not the end of the matter. Then turn the page, the extracts of the terms of reference are given. Then come to 356. Action has already been initiated. The letters addressed by the Honorable Governor of 5/7 and 15/7 are annexed. A detailed reply. So the governor asked, what are you doing about the so-called Muda scam? The reply is given, the Commission of Inquiry looking into it. So the governor gets the response about good governance, which the elected government thinks fit. Then all those letters are given in para 5.35. Now come to the complainant's part at 357, come relevant to 358. Para 6.2, the crux of the complaint is Parvati has been compensated for having lost her lands without the due process of law. She's my wife, Malas. However, in view of the fact that Parvati's constitutional right under 300A has been agreeing to 50, that's the crux of the matter. Then, Malas, it goes on. They say in 6.3, third line, entire allegations made by Abraham in his petition, even if admitted to be true, do not disclose any offense. So you can tell, the governor can say, disclose an offense for this reason. Doesn't deal with it. Then, Maharaj, next page 359. Fourth line, 6.6. The fact of the matter is that pursuant to the alleged family arrangement between the brothers, Mallaraiah transferred the property to Venkatama. Therefore, the lands have come back to Swami, son of Mallaraiah, and thereby by way of deed of family arrangement recorded in so-and-so. All days are given, Maharaj. The first sentence says, Mr. Abraham is suppressing throughout. It gives all the facts. Then, Maharaj, 362, 6.8, the claim that possession was with Muda is absolutely baseless since no possession notification or Amazar taking over possession is required has been drawn up. Then 364, this talk about, I'll not read all these facts. Dr. Mark 364, 365. Then, we also talk of further suppression in 366, in 6.24. We give the things which he has suppressed, the second part of para 6.24. It gives the suppression. And so on. Then come to 376. Then the law on sanction is fully dealt with. 380 tells the lordships sanction is necessary at the bottom of 380. I hope I'm clear, bottom of 380.
There, sir.
Then, Malas, 384 tells you that the stage for this sanction comes, Malas, at cognizance, which is not the stage. That is, Malas, 384.
Right.
I'm very grateful. I'm very grateful.
Yes.
Then, Malas, 388 tells you the point I'm about to make, that it can be only by a police officer. 8.3. Now, these are reasons. What else the cabinet can do? It can give you every possible reason in law and fact. You deal with it. I'm not saying my main case is you are bound also constitutionally. Forget that for a minute. You're not bound. You still deal with it. Then, Malas. Now come to what my Lord Malas notes. 218. It is important. At 392. The Sanhita, which is 218 Malas, makes it amply clear that the said provision comes into play only at the stage of prosecution and taking cognizance of offences by a competent court of law. Furthermore, the nexus, etc. Then, Malas, 394 onwards, this exact judgment I have read to your Lordship is cited. 394. And goes on till 397 with Yedurappa. Cited and quoted. My learned friend makes it sound as if I quote the law of the land, I am being frivolous or I am being too detailed. I am quoting the law of the
I have
land.
never said either of these two.
No. This is my
Ah,
adding color to your colorful expressions.
yes.
Now, Alice.
I have no, I
Now,
don't have the
413.
privilege of using colorful expressions.
Now,
That's the
413.
privilege of a person, Dr. Singhvi, who is both in public life and professional life. I will have to, I can't use adjectives.
Anyway,
Yes.
the time being, I let it pass, Malas.
Let's not go on colors.
Yes.
Yes, Malad.
Now, Malas.
Everything is black and white here.
That is correct.
Monochrome.
Correct.
That is correct, Malas. That's the
Yes.
way it should fall from the judicial side of the organ, Malas. That's absolutely right. Your Lordship is having that in the paperwork.
Yes.
Now, this antecedents, look at Malas, the habitual thing. I'm not saying you could dismiss the complaint of antecedents. Just see the para. We have dealt with it, 12.1. We've given facts. Mr. Abraham, history of criminal antecedent.
So we have dealt with means what? You are chief minister.
No, this document which is before the governor has dealt
You
with
said
it.
we
He
have
has to
dealt
deal
with it. Therefore,
Yes.
chief minister has not dealt with.
I hope the
Cabinet
best. My learned friend has made two best arguments till now.
No,
These are
truth
the best
has a
arguments.
strange way of coming
Two
out.
best
You
arguments
say
are, first is,
we
I
have
am the
dealt
governor, give me time. Second is that this document should not have the word we. I can't divorce myself from the fact that I am the chief minister, elected one of the state.
No, this is
And
not.
this
this
is a
is
What is
document
not
with the
prepared
sanction.
by
And
the-
No, this is reply by the chief minister.
no,
No,
this is.
because
I'm
This
saying
is
cabinet
cabinet
decision.
note.
No, decision
So
of the
I'm
cabinet.
saying, my learned friend is saying, well, just see the antecedents. Just see antecedents.
Yes.
Is it not relevant for the
My
honorable
learned
governor
friend
to
could
have
not
seen
use the
this?
word.
They
we have
pointed
dealt
out
with.
that he was a habitual blackmailer and court bird with history. Supreme Court has strictured him. I've quoted that in terms of the document I'm reading, not that I have drafted the
Okay,
document.
that may not be
Yes.
relevant for a decision
Yes,
from
that's
the-
all right.
whether there is
No, that's
application of mind or not.
Now, this is very serious.
Yes.
The cabinet finds it to be selective Article 14 discriminatory arbitrary treatment by the governor. See that, para 13.3. That's a separate point by me. Just read this very, very important one.
Yes.
The selective treatment of Abraham's petition, same day, given
Yes.
the governor's inaction on numerous other pending petitions, such as proposal for prior approval under 17A, against nominal, every detail is given. Shashikala Jolie, dated 2021. Supersonic speed, same day versus 2021, 3 years ago. 3 years ago. The proposal dated 26th February 24, Murugesharani. That is 6 months ago. Janardhan Reddy. These facts strongly suggest that extraneous factors influence the governor's decision. The Supreme Court has emphasized that actions based on extraneous, etc., Bommai political vendetta. And then, Malas, the final advice is at 420. I would say, Malas, whether appropriate to one side or the other, the page number is appropriate. Now, this page number is also gone in the new sign.
No. That's what I was telling when
Now
I
the
was
page number is
holding.
gone in the new sign.
The biggest change in, they said, no,
Gone.
there is no change. The biggest change is 400 base is gone.
It's a psychological
Cheating
change.
is gone in BNS.
But Malas, may I say, 420 was never a section. 420 was a metaphor, always.
Yes, that metaphor is no longer in existence.
You also
Because,
remember the very old Bollywood film in black and white?
yes, Sri 400 base, that is also
So
gone.
it was a metaphor, Malas. That metaphor will always remain, whether you have
Metaphor
many
will
signs.
remain.
That's right.
But 400 base goes away.
That's right.
Yes.
So, well, now the final order is the Honorable Governor ought to have, under the present set of facts, acted only on the advice and aid, not in his discretion. While proceeding to issue show cause, failed to consider the material available, ought to have taken into consideration the reply submitted by Chief Secretary on 26/7, received by the Governor at 6:30. Chief Secretary inter alia highlighted the direction, constitution of Judicial Commission, etc., etc. And then, Malas, all these reasons are given, and finally said that you are obliged to. As far as I'm concerned, I've separately filed a reply. I have not said that, look, I'll not file reply because you are acting without jurisdiction, which you are. But without prejudice, I filed a reply, detailed reply. He has not considered that. Some of your lordships can add to the fact he does not consider the cabinet's note. He does not consider my reply. Obviously, they will overlap in terms of content, in terms of substance. Now, let me come to the, so this is the one major point, in terms of the proposition. I go to the next one immediately. Is you, as the governor, are acting in a judicial reviewable capacity in granting or not granting approval, which my lord actually rightly and pithily summarizes as 17A/218. What you say is judicially reviewable on the standard classic grounds of relevant considerations, extraneous considerations, Wednesbury reasonableness, eschewing this thing or that thing, etc., etc. Lordship knows that well. Forget that. My lord doesn't have to do that exercise. My humble and respectful submission is there is nothing. Your lordship read the order. Your lordship will do the exercise of Wednesbury reasonable after you see some reasons. The only sole reason is I am not bound by your advice. Hence, sanction or permission or approval. This is proposition 1 with the 2 judgments. The second is 17A, my lord read in the order. Now just note 2 or 3 things. Just take 17A. I'll just be very brief. 17A. I don't have to read any case law, though there are many. The section makes it clear. PC Act 17 capital A, as the lordship knows well, came in 2018, July 2018.
Yes, 26/7.
No police officer shall conduct, and it starts with that.
Yes.
No police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant. So, alleged to have been committed by a public servant, where the alleged offence is relatable to any. Now, just look at the. Are you not violating the legislative intent patently? Just give me a second. Put a full stop after the word act on the 3rd line. They limit. They don't put a full stop. They add a suffix. No police officer shall conduct, but additionally, even if he conducts, suppose if it's a non-police officer, the first condition goes, you can't do it. There is no police officer here is the complaint. Second condition is supra-added.
Not yet.
Yeah, that's right.
Not yet a police officer.
Not yet. That's correct. No, we are talking of now the 17A stage, which is mentioned in the order. We are talking of that order. What will happen later is different. Now, where the alleged offence is relatable to any recommendation made or decision taken by such public servant in discharge, as my lord noted, of his official. Now, where there from 92 to 22, the file never came to be in any capacity. So, neither decision nor recommendation. What you are really confusing is with an alleged beneficiary to constitute, sir. So, you can't violate the section like that, on the face of it. You cannot violate the language of the section. Now, please see. This is still granted. Despite that, there are 3 judgments your lordship may note, Sri Rupa, I believe, which is
all are mine.
My lord judgment.
All 3 you have cited are mine.
I always am very hesitant to cite a case authored by the same judge before whom I am arguing. I appeared many moons ago. I have told this to many people in Supreme Court, and my learned friend has heard it also.
I saw the index, and all 3 judgments are mine.
So I am grateful, your lordship knows it well. Lordship will not have the citation. Give it to my learned friend, please. Kindly hand it over to him.
Yes.
I was telling your lordship the slight aside, which I have told my learned friend many times in Supreme Court also. I was arguing a matter before Justice Chinnappa Reddy. And Justice Chinnappa Reddy, I came across 3 decades ago. I cited a case on all 4s in my favor. And it was authored by him as Highcourt, Andhra Pradesh judge. So afterwards, he had a very twinkle in his eye and a sense of humor. So after 2 minutes, he says, but Dr. Singhvi did not realize that I was waiting for a chance to overrule myself. So I am sure your lordship is not waiting for that chance. Each of these 3 judgments, may I save time, It's not to be brushed aside. my lords.
It's on application of mind.
No, your lordship has given reasons.
Yes, I have reasons.
It can't be just ignored, my lords. I mean, I can understand there's a contrary division bench of Karnataka, there's a contrary Supreme Court. How can there be a contrary Supreme Court of what your lordship has written, my lords? With great
I
respect.
don't know if Supreme Court has written.
No,
something.
on this point, there can't be, my lords. What has your lordship said? My lord has said that on 17A, the conditions precedent of the sections have to be, the mind has to be applied. Mind will be applied to what, my lords? To the condition precedent of the section, obviously. So this is not something which, my lords, it can be overruled. Your lordship has applied the law. And all three judgments, lordship remember, Sri Rupa, Dr. Ashok V, and Praveen Kumar.
Yes.
Three judgments. Your lordship has got the paras, or may I? my lords?
First one was Praveen Kumar.
Yes.
Gulbarga-
Praveen is 14 to 16 para numbers, and well as the others are 23 to 28 is
Yes.
that Sri Rupa. But my lord knows this. So you give the pages to him on the compilation. Otherwise, I don't want
It's
to
here, sir. I'll
repeat
go
it.
through it.
Now, note two more things, Balas, on 17. So first point on 17A is conditions precedent of section. Number two, your lordship's judgment. Number three, there are two circulars about criminal law approach and investigation under 17A. One circular is by the High Court of Karnataka. Just
That
turn
is
to-
after judgment in JV Ashok.
I'm grateful.
Yes.
So one is that, Balas, at 260 of the paper book. Just note that.
They've given that.
And there is
circular.
one by the central government, a SOP. One second.
Which is the central.
First one is 260, just for 15 seconds, just pause it that, Balas.
260.
Yes, that is 23rd September 2023.
Volume 2.
Huh? Volume 2.
Petition. Writ petition.
No, the writ petition, no, not the law, Balas, not the law compilation, the main writ petition file.
Page.
No, please. First is 260. I'm on the High Court of Karnataka Circular.
260.
They emphasize it is mandatory. Please follow it
No,
strictly.
this is
That's
after
all.
Dr. Ashok's.
That's right. So I'm just pointing out the circular 260 of the paper book. Now the second one is 703, which is the last page document which my learned friend was saying. On 3rd September 2021. 703.
Yes.
And the last three paras of that are relevant, which are paras 2, 3, and 4 at page 704. So as to standardize and operationalize procedures with a view to achieving uniform and effective implementation for prior approval processes, a set of SOPs are hereby conveyed. The SOPs provide for stage-wise processing of information received by a police officer, specify the rank of police officer to seek prior approval under section 17A. Considering the proposal under 17A by the appropriate government or authority, laying down a single window. Well, if the condition because section is not looked at, so where is the question of doing all this? All administrative authorities, including ministries and departments of central and state governments and IAs, investigating agencies, are requested to take note of the SOP as appended herewith, bring to the notice of all concerned, etc., etc. So I've done 3 points. Natural justice is clear. The first point was name of Mr. Abraham. Actual order has 2 more. Those 2 more never supplied to me. The order is based on those 2 also. Second point is he does not discuss or give any reason. Third point is 17A. Fourth point is 218. Can you turn to 218? What is the point here, Malas? At page 47, the learned governor grants Malas an order which invokes 218 of the Sanhita. At page 47.
Yes, I am there.
Right, Malas? Now, Lordship knows in pari materia 2197 and all that. Now, the language of 218 itself makes it clear that it has to be offense specific, ingredient specific.
Yes.
Resistance to taking of property by lawful authority of a public servant. Whoever offers any resistance to taking of any property by the lawful authority of any public servant, knowing or having reason to believe that he is such public servant. So knowledge is important, Malas, mens rea. Such shall be punished with either description. But suppose I go to somebody and say, you're guilty of 218, you're guilty of 218. 218 is not an end in itself, Malas. You have to show what 218, what ingredient, what offense, how. How is important. See page 47. Lordship find nothing. Page 47 is nothing. It says exactly what I am saying. 218. There may be other points I'm not arguing now on that point that 218 came now. This offense relates to when.
No, since.
But that's all right. I'm not, your Lordship will have to see whether it applies back or
It's
not.
taught after BNSS and being granted. It is only BNSS.
I am not even arguing that for the time being.
Yes,
I don't
that's
want to get into that. Now there's two more things that I'm done. One is, well, it's the larger issue of selectivity of these four other complaints, which my lord has noted that one page of the cabinet
That I
decision.
have seen. Let them all file their
Names are given.
objections.
Names are given there. Details
No.
are given.
Let the respondents file their objections if they want to.
That's right. If they say that, look, for this reason, I could not decide a 2021 complaint, but I decided yours on the
So
same
that
day.
let the, even the
So, Manoj, I am saying,
SG is learned SG is
So
representing the
my
governor.
instructions are there are no
no,
sanctions
let,
pending.
let me end.
Yes.
Let me just end. Please allow me to finish. Manoj, one thing which is larger issue, not today, but Lordship should know the flavor of it. Just turn to 155 para number of Nabam Rebia. I'll be very brief because
155.
para number. Now, I hope we get it correct this time.
Page
869. Keep on turning it inside it.
Para 155.
Now, 155, that your lordship's 1027.
Summarize our conclusions.
Right. Firstly, Constitutional Bench is summarizing the measure of the discretionary power of the governor. So there's no point, my learned friend, just was flushing it aside by saying, oh, it's a 10th schedule case. It's a 10th schedule case which arose in the context of an intersection with the governor. The governor tried to interfere. The court said, you stay put within 163.
Yeah.
Directly arose. So, my learned friends, well,
So here, sanction has to be accorded by the governor only.
correct. No,
it-
we are not
him
on the
being
governor.
Bound by the advice of the Council of Ministers
Where
would not.
where the chief minister is no party of the decision-making process.
That will consider.
That's
Yes.
now let's just see. Firstly, I think this point for a minute I'm assuming against myself. I'm just
Yes.
putting it because I opened with the other point.
Yes.
But I'm just putting it for 2 minutes and ending on that. The measure of the discretionary power of the governor is limited to the scope under 163(1). Now, 163(1) doesn't say that you can say blanket the entire cabinet is disabled because the chief minister is involved and he appointed you all. You can't say that. That's too general. Then, Malas, all the cases your lordship has of conflict of interest are where I am in some way directly myself deciding my case. It's not this case. Then, Malas, secondly, under 163, the discretionary power extends to situation where a constitutional provision expressly requires the governor to act in his own discretion. Expressly. None. Thirdly, the governor can additionally discharge functions in his own discretion where such intent emerges from a legitimate interpretation of the provisions concerned, and the same cannot be construed otherwise. Fourthly, in situations where this court is declared, sometimes a lordship says you shall decide. That is not this case. And lastly, Malas, fifthly, or 163(2), final and beyond the scope of judicial review, answer no. Answer no. Now, Malas, two things I've done here. I have read to your lordship the last word of a constitution bench. I have read to your lordship 163, which is directly relevant to the governor's powers on the larger issue, not argument. Just one thing and I end, Malas. Just to tell your lordship why my learned friends, Malas, instructions are wrong on this. Note this, that MP police judgment, which is in your lordship's file at page,
Yes.
just note these paras. This your lordship may note because it will be difficult to
242.
find out. Yes.
No, 262.
But just note these paras.
Yes, that's all right.
No, I'm sorry. My apologies. I meant something else. The paras of Navam Rebia, which deal with MP establishment, those paras.
Which is that?
Para 116. Lordship may note the paras. Lordship will see it later on because it's not being argued now.
Yes.
So clearly, Navam Rebia will govern, not MP. The governor cites only MP. Now see those paras. 116, 118, and 118 may be ticked by lordships in particular. I'm emphasizing it. 128.
See, this is exactly the point. There was a case where governor had to act or was required to act on the aid and advice of the Council of Ministers because he is not acting on his own. Now here is a case where sanction has to be accorded by him acting on his own with application of mind is imperative. Yes, that you may say.
Very well, I
But
will.
according this judgment may not be
No,
prima
why
facie.
not? Why not? My lord, therefore, I'm only saying Nabam Rebia and MP will be considered at final hearing in some form as to how much of
That
MP
will-
remain. That's all I'm saying. Let
That
me
I
not argue it now.
Because what was imperative in there and imperativeness
Yes.
here are totally different.
Now,
Playing the
bow
role
down.
of the governor.
I bow down to that.
Yes.
Well, lastly, two things. First and foremost, fellas, the governor is a person who has spoken in his order. If I don't make him a formal party, we make even tribunals a party frequently. But they don't necessarily, he cannot have an interest in your lordship granting me or not granting me interim protection.
That will.
No,
will
I'm
answer
just
it.
pointing out, fellas, because it's easy that I'm a governor, I've come, therefore give me. I'm saying he may be there. He may come and deal with it. But he can't be personally interested in expanding, rewriting, or supporting his order beyond the interim stay which one is seeking today. Number one. Number two, and it would be very odd for a governor to do that. It will validate my point. Number two, it is clear that the matter is before the court tomorrow. Now, you will have cognizance, you will have pre-cognizance and post-cognizance actions. The whole idea is to then start a process to undermine and destabilize the government. Number three, it is also constitutional law, law and politics are intertwined. We are not, we don't live in some ivory tower, cloud cuckoo land. Your lordship is not in a, that a storm is coming, so I'm an ostrich, so I put my head in the sand. That's not the way judges function. So immediately then, a whole process starts clamoring. There is, of course, nothing in law short of a conviction which affects your resignation. But the idea is, why start a process which is on the face of it, 1992, 2024, today you go to the governor same day issues show cause. Within 2 weeks, we are less than, let's say, 1 month. And he must, your lordship, on what balance of convenience must there not be a status quo ante as of prior to the order of the governor's date, the governor's order? On what basis? If heavens have not fallen from then to now, and on what basis will the one day before the order of the governor, not be a valid balancing of equities, not be a valid irreversible consequence test, not be a valid balance of convenience test? And governor, just because of stature, should in fact keep away more aloof. He should not be saying why no stay.
Anybody has to reply, we will see.
My lord, only 5 minutes, my lord, because I have yet to go through it,
No,
my lord, but I have
go
an
through the
answer.
papers, file your objections.
My lord,
All of
I
the,
have
who are
only,
respondents, let them come up with objections.
yes, certainly, my lord. My lord,
Detailed
only
objections.
few facts, my lord,
Yes.
without going into the merits, my lord, because my
Yes.
learned friend said something, and we have an answer, my lord, in law of everything, my lord. I represent the governor, the office of the governor, and therefore, my lord, I do not have the luxury of, my lord, using adjectives like friendly governor, etc., because it would not be in good taste. Suppose I also start saying subservient cabinet or a corrupt chief minister, doesn't look good, because all are constitutional functionaries, and irrespective of the party position in the petition, whether we are petitioner or respondent, we must respect the constitutional office. Lord, the three questions, my lord, which I'll have to answer, my lord, first would be the power of the governor in granting sanction under 17A vis-a-vis the cabinet decision. I'll be able to show para to para, page to page, cabinet decision and the pages of the petition, verbatim same. If cabinet decision is first, then it's okay. Then, my lord, the person who has drafted the petition is guilty of plagiarism. But if the draftsman is same, then the cabinet is guilty of non-application of mine. But that's, my lord, on facts. In law, MP, my lord, governs the field, and MP judgment, my lord, clearly only, my lord, one paragraph, if your lordship permits me to cite, my lord, concludes the issue, my lord, so far as the constitutional position is concerned. My lord, please come to, my lord, that MP judgment. I don't have, my lord, my learned friend's compilation, but MP judgment, para 14.
I've not even argued for the time being. I've not even argued. I started, I left it there.
Para 14. Mr.
Yes.
Dr. Singhvi, you argued for 2 hours. Give me a few minutes.
Yes, sir.
I'll confine to the constitution and not any spicy expressions for media. But please see para 14.
Yes, sir.
As has been mentioned above, your lordship gets, my lord.
in
My lord, MP Special Police Establishment versus State of
that's
MP.
225.
Yes, my lord, it's a constitution bench judgment where precise question was the power or responsibility of the governor while granting sanction, whether he is bound by the cabinet decision or not, whether aid and advice of the cabinet would be binding on the governor or not. Para 14 starts, my lord. I am not reading the entire judgment at this stage. My lord, I'll
Yes.
assist your lordship, my lord.
Yes.
But your lordship may not find that
Lord,
judgment.
14, my lord.
Can I
Where
give
do
you
I-
a copy? You can give a copy. My learned friend is giving a copy.
14 and 19, my lord, two paragraphs. My lord, that summarizes the law. And my lord, whoever has prepared the cabinet note, my lord, has relied upon this, unfortunately, forgetting that their counsel would come and dispute that by citing Nabam Rabia, which is completely irrelevant for present case. 14, your lordship gets, my lord?
Yes, I'm there, sir.
As has been mentioned above, the division bench had noted this case. The division bench, however, held that even though this principle may apply to the case of chief minister, it cannot apply to a case where ministers are sought to be prosecuted. We are unable to appreciate the subtle distinction sought to be made by the division bench. The question in such cases would not be whether they would be biased. The question would be whether there is a reasonable ground for believing that there is likelihood of apparent bias. Actual bias only would lead to automatic disqualification where the decision maker is shown to have an interest in the outcome of the case. Principle of real likelihood of bias has now taken a tilt of real danger of bias and suspicion of bias. Now please come to my lord 19. They are saying
Yes, sir.
when the cabinet is deciding about the minister or a chief minister, what will be the contours of the power of the governor?
Yes.
Para 19, my lord.
Yes, sir.
Article 163 has been extracted above, undoubtedly in a matter of grant of sanction to prosecute. Governor is normally required to act on aid and advice of the Council of Ministers and not in his discretion. However, an exception may arise while considering grant of sanction to prosecute a chief minister or a minister where, as a matter of propriety, the governor may have to act in his own discretion. Similar would be the situation if the Council of Ministers disables itself or disentitles itself. Mr. So-and-so on behalf of ministers submitted that the case of chief minister would be completely different from the ministers. He submitted, my lord, not relevant. My lord, court says no. It applies to both, and there would be an apparent likelihood of bias if the cabinet decides, because the cabinet is appointed on the aid and advice of the chief minister by the governor. And para 32, my lord, of this judgment. On these facts and circumstances, the governor cannot act in his own discretion. There would be a complete background of rule of law, etc., etc. There was material before him, prima facie, etc. The second question, which I'll deal with, my learned friend's contention that the governor has not dealt with, parawise or otherwise, the decision taken by the cabinet notes. There are twofold answers. Answer on facts. The cabinet, the governor has taken a view that the cabinet's decision is not binding on me based upon the principle of law laid down in the 5 judges case. And therefore, there is no question for me to examine whether it is right on merits or not, because it has no jurisdiction. Second, and without prejudice to the first, there are judgments to the effect that even while acting on the aid and advice, the governor cannot sit in appeal over the decision. He is not an appellate authority who will, my lord, go into the matter. I'm sorry. Go into the merits of the case. My lord, your lordship's judgments on only police can seek approval and not my lord, that helps, my lord, that assists, my lord, your lordships again, my lord, for the facts of the case. But it's a reasoned order passed on file. I'll place it on record. And whatever, my lord, constitutional position, I'll assist your lordships.
All right.
I would request, my lord, any date, my lord,
We will,
because Once, my lord, the governor, who is a constitutional functionary, has granted sanction, lord, injunction of any kind, whether direct or indirect, by another constitutional
No,
body
true,
may be
but,
avoided. That's all.
the submission, we have to hear and readings have to get complete. The
Yes,
submission
yes.
is that the matter is tomorrow. This should not be rendered fait accompli by any action taken by the concerned court.
Lord, unfortunately, in our legal
all.
system, nothing happens in a day in a court of law, my lord. My learned friend can, my lord.
Act on the sanction. But they can't act.
No, that's why.
Because, my lord, indirectly also,
We'll,
the lordships
we'll
would
post
be
it day after tomorrow or Thursday, whichever day you want.
Thursday, my lord, Thursday.
Thursday.
Thursday, my lord. We'll
We'll
file
post
on
it
the spot by
Thursday.
day after.
Let not the court proceed further till Thursday.
My lord, they can seek time, my lord. I mean, there are ways and ways, doctor.
No,
We
High
know.
Court is saying,
let it not.
No, the complainants are here, but the complainants are here.
Complainants are
Court of
here. my
Lordships
lord.
deferring the staying the proceedings. But
I'm not-
no,
I'm
just-
not granting anything of that kind. Wait.
This
yes.
is not an ego fight. Well, your lordship is only saying not till Thursday. It's not that well, we have
No,
to.
no,
well,
it's not an ego fight. The question of
My
constitution.
learned friend is not going to be well as part of the proceedings there.
I am not going to
It's
be.
a
Yes.
No,
accused.
no,
No, no, I understand. I understand, Dr. Singhvi.
SG sir.
92 to 22 proceedings till
No, that
Thursday.
I will everything I will answer. That's a different thing. SG sir, I just wanted, see, day after tomorrow, if the proceeding is there and he would proceed to pass some order, then these proceedings should not, they may not become
Infructuous.
infructuous, but
I bow
why
down.
a fait
I'm not.
accompli?
I'm for a second not, my lord, either supporting or opposing, my lord, the state, because
That's why,
it's
sir.
for the complainant to do. But
No, because we are
Govern-
hearing the matter, hearing is
no,
whole
no,
hog.
certainly, but lord,
Yes.
I have a suggestion to make. Lord, the governor having
No,
granted
whatever
the
matter is tomorrow.
Lord, governor having granted sanction tomorrow, any
No,
Ma'am,
I'm
please
telling you, see, this
always-
Superior Court, 1 minute, yes.
ma'am, if you don't mind,
Well, I don't understand why the SG is arguing on the interim stays.
No,
Your
no, I'm
lordship
not
well,
arguing on
has to
interim.
No,
explain
he's,
to-
no, he fairly said that he's
I'm-
neither
I'm-
against nor for.
I'm
I
neither
hope, well,
against
that,
nor.
that sentiment is maintained. Well.
Lord,
That is, that's
my lord,
not, yes, sir.
principally,
He is not-
principally, my lord, constitutionally, once
Yes, yes.
the governor's sanction under challenge, based upon which some proceedings are on, my lord, another constitutional body, namely the court, would be very wary. I'm not saying there is no
And
jurisdiction.
well as the High
Say
Court, the
anything.
superior body,
Only a minute,
sees
Dr.
of the
Singhvi,
matter,
now.
and the trial court should
Dr.
proceed.
Singhvi, please. For
Wait,
me,
sir.
it is only a matter, not even a professional matter. My lord, instead of your lordship saying, let the complainant say that both can seek time, my lord, and there is that,
I will,
can be
I
taken
will
care of.
appropriately balance it.
That's
in
That's all,
order.
my lord, I am suggesting. My lord. We are before your lordships, and we would not do, my lord, I would not like anyone to do anything
Matter
which.
which is listed tomorrow before the special court.
Hmm.
Lord, section 17A, my lord, which came to be inserted in the month of July 2018. The offences alleged are right from the year 1998, my lord. There are sequence of events which are described. Now, my lord, whether section 17A would apply to the crimes alleged to have been committed before, my lord, the insertion of section 17A is to be looked into.
Check Thursday.
So therefore, the instant proceedings, my lord, would not, my lord, affect the proceedings before the special
So that
court.
decision is not required, is it?
No,
Whether it would apply or not?
Simple submission is that.
Mata?
Now, my lord,
Huh.
tomorrow's proceedings, my lord, I mean, much reference is made to the
It's not
proceedings before the special court. Kindly, my lord, no orders, my lord, in connection to the proceedings before the special court, pursuant to the PCR, my lord, can be passed, because the same is not in question before this honorable court, my lord. It's only the validity of the sanction order that is under
No,
question.
no. The consequence is what the learned senior counsel is saying. Try to understand. A superior court now is holding these proceedings with regard to questions to be answered by this point or to by this court.
Absolutely.
Now, at that point in time, some proceedings are taken up there, which would frustrate these, not fait accompli. Frustrate these proceedings will not be correct.
If at all, my lord, if at all, the petition, my lord, succeeds in the instant petition,
All right,
then, my lord, even then, the Sadak series case, my lord,
all
which
right.
is clearly on the point that
Huh.
when there is fabrication of documents alleged
Against
Lord,
whom?
against all the accused persons, my lord, against the accused number 1 to 5,
Hmm.
when there is fabrication of documents alleged,
Hmm.
certainly, my lord, the question of sanction does not arise at all. My lord, complying with my lord's judgment in Dr. Ashok's case, I had, my lord, as a procedural formality, I had applied to the governor. The same, my lord, does not mean that I accept the proposition that only with the aid of sanction under section 17A, I must approach the special court. Because in the instant case, the alleged offences are much prior to the date of insertion of Section 17A into the Prevention of Corruption Act. Therefore, in the Shadakshary's case, my lord, very clearly, my lord, Justice Oka's headed the judgment. The judgment rendered by the bench headed by Justice Oka.
All right.
It's clear on the point, which clearly states that when there is fabrication of documents, it is nobody's discharge of official duty. It cannot be considered as discharge of official duty. And even Section 17A, my lord, it clearly reads at the end of the definition, my lord, which my lords may kindly peruse.
There is fabrication against the chief minister also?
Lord, there is Section
Direct
120B.
question, direct answer to a direct question.
Whenever Section 120B is, my lord, alleged,
Conspiracy.
please, there is conspiracy.
Conspiracy.
Please,
That is all.
absolutely.
Yes.
When there is conspiracy, my lord, it cannot be said that it can be
That's all right.
individualized.
That we'll see.
The act of one is the act of all.
That we'll see.
When there is 120.
Oh, don't say all for one and one for all here.
Please, my lord. Section 17A, my lord, if my lordship may kindly peruse.
That I have seen, sir.
Please.
Tell
Now, no police officer shall.
All right.
My lord, here.
That is after registration of crimes.
Absolutely, my lord. Now, since Section 17A sanction is obtained, it would, my lord, facilitate the special judge, if at all, if he so comes to a conclusion that
We'll see.
the matter deserves referral to the police officer.
You file your objections.
Absolutely, please.
In your, yes, now,
I appear for the.
respond number 4.
I
All
appear
all of
for-
you file your
I
objections.
appear for the respond number 5. Only, Lord, on the question of interim order, Lord, I thought I must bring to Lordship's notice. Hello, sir, 1 minute, I'll just cover it. 1 minute. But on the question of interim order, Section 17A, but on an earlier occasion, this situation came across where the sanction was challenged. This court, Lord, division bench has taken the view that there cannot be a interim order of stay insofar as under the Prevention of Corruption. But let me point out that. Okay. If lordships are to, this is the division bench order, which is not later on has been referred
No,
to.
this is why Justice Mukherjee or order idaadmele agide.
Idaadmele, but subsequent, kindly see at the stage of interim order, how is that the lordships dealt with it? First page is the prayer. First, may I now request lordships to kindly see, Lords, internal page 9. Internal page 9. Indeed, insofar as the grant of interim prayer is concerned, it is no doubt true that interim prayer which is sought for the writ petition is sweeping in as much as it seeks suspension of all proceedings pending disposal of the writ petition. Indeed, the question would be whether such a request can be granted. In these regards, certain provisions of the Prevention of Corruption Act 88 is required to be looked into. Section 19 of the Act would speak about the previous sanction to be granted for prosecution with respect to public servants. Subsection 1, Lord, their lordships refer to subsection 2, subsection 3. One second. But kindly see in internal page 10, second paragraph. Indeed, we have not this. Indeed, we have not reached the stage of subsection 3C of the Act. Insofar as subclause B of section 13 is concerned, we have also not reached that stage. We are yet to see whether there is any error, omission, or irregularity in granting the sanction, which has occasioned the failure of justice. This is a question which is required to be thrashed out when the matter is heard finally.
Yes, I have seen.
Then, Lord, their lordships refer to Siddaramaiah Sharma and say, 19.3 prohibits the court from considering grant of interim stay, but Siddaramaiah Sharma says it also applies to the High Court.
No, there was sanction under section 19.
No, that's true.
Stage was after investigation and a final report being
I
ready.
request now lordships to kindly see section 19 once again.
19, we have not yet reached that stage.
No,
at all.
the subsection 3 applies to all proceedings under that. That's what I want to
All
point out.
proceedings under the Act, qua section 19.
Lords,
We are at the threshold on 17.
May I request lordships to kindly see 19 for a moment. 19
Yes.
subsection 3. (19.3) subclause C. Notwithstanding, Lordships get it.
Yes, I'm there.
Notwithstanding anything contained in the Code of Criminal Procedure, see, Lordships may kindly see and
Yes.
kindly see the emphasis. No court shall stay the proceedings under this act. But
Even this
it's
court?
not COR 19. No, it's
Even this court?
look, the Satyanarayan Sharma, this is exact now kindly go back to the judgment.
Yes, sir.
This very question was as to whether this would also apply to the High Court. And Lord Satyanarayan Sharma says at internal page 11, may I request? Internal page 11, Lord, may I? But however, there is a clear embargo on stay of the further proceedings. Indeed, the decision of the Apex Court in the case of Satyanarayan Sharma reported in AI so, wherein a similar, if not identical question fell for consideration. And the Apex Court was of the view that when a sanction is sought to be questioned elsewhere, the question of suspending the proceedings would not arise. The Apex Court has observed as, and then what the Lordships refer to 482 itself. Thus, in cases under the PCA Act, there can be no stay of trials. We clarify that we are not saying that the proceedings under 482 CRPC cannot be adopted. In appropriate cases, proceedings under 482 Criminal Procedure Code is entertained. There can be no stay of trials under the Act. It is then for the party to convince the concerned court to expedite the hearing of that. This
Right.
principle.
Principle true, sir.
Yes.
There can be no qualm about the principle at all. Those were cases where investigation was complete, sanction was sought for prosecution. We are at the threshold.
No,
We
not,
are at the threshold where 17A is
that's
being
true.
debated
No,
upon.
I want to address your Lordship. In
That's
fact,
the only
I
thing.
wanted to submit.
See, it is like this. Now today, this court is hearing the matter. The other court pursuant to the sanction passes some order which would frustrate the proceedings before this court. I for
No,
one will not permit.
No,
that.